In the first part of today's lecture, we looked at the basics of the international criminal justice system and the International Criminal Court, the ICC. In part two, we're going to look at the case for the ICC, the case for the International Criminal Court. A central aim of the ICC, according to the Rome Statute, is the ending of impunity, which is widely seen as central to the occurrences of mass atrocities.
Well, the first preambular goal of the United Nations Charter after World War II was to save future generations from the scourge of war. One of the worst scourges of war are war crimes, crimes against humanity, and genocide. This independent court and new system of justice created by the Rome Statute in 1998 is a miracle. It could not have been agreed to a year earlier, and it certainly couldn't have been agreed to a year later or up until now. Even today, there's no chance that the strong treaty that was agreed to would have any chance in our current geopolitical environment. So governments have created something amazing: an independent court, independent prosecutors, an appropriate relationship with the UN and the Security Council, extreme advances in gender crimes, internal armed conflicts, and even non-armed conflicts like disappearances apply. No impunity, no immunities. I mean, this was a court that could work. And it was a tremendous achievement of the international community in 1998, and it's a real challenge to protect it and to help take it forward.
How successful has this been? On the one hand, there's been only a handful of convictions in the time since the establishment of the ICC 18 years ago, 2002. It seems unlikely that it's made much of a difference. After acquittals, there are now only 3 indictees that are left. In addition, trials often happen only a long time after abuses have occurred. It might seem then that the ICC can't make much of a difference in terms of addressing ongoing abuses, and it's only post hoc after the event. Yet some do argue that it is important. Let's look at these arguments. First is through the process of ratification. By ratifying the Rome Statute and agreeing to be governed by the ICC, it's argued that those in signatory states, rebels, governments, much less likely to engage in mass atrocities. This might be because of the direct fear of prosecution, but also because of the shift in culture, as mass atrocities are strongly delegitimized by ratification. Indeed, it's been found that the ratification has a very sizable effect on the counterfactual amount of intentional killing. Namely, it reduces it by about 60%. So ratification might help to reduce the likelihood of mass atrocities occurring in the first place. States that have ratified the ICC seems far less likely to have instances of mass atrocities. But this doesn't say much about the case of actual ICC prosecutions and the effects of ICC amongst ongoing cases. So let's focus on the case for prosecutions rather than simply ratifications. Okay, just move myself up so I'm not in front of William Pace, major figure in the NGO movement in defense of international criminal justice. 5 main arguments for prosecution rather than ratification. 5 main arguments for these 5 camps. And these essentially track the arguments for the ethics of punishment more generally. That is the ethics of domestic punishment. In punishment theory, there are 5 main reasons to punish. Let's go through these and see how they apply in each case. The first is prevention. It's not simply to stop the criminal from committing the same crime again. By imprisoning, for instance, mass murderers, sexual offenders, it stops them from being able to commit this crime again. Now, this might apply to some that have been subject to prosecution by the ICC and to some prosecuted by other special trials, such as Charles Taylor. Putting major figures on trial and imprisoning them can stop them from committing mass atrocities again against their own population. The second is rehabilitation. This concerns trying to rehabilitate criminals to bring them back into society. Picture of Morgan Freeman here, famously from one of the best films ever, Shawshank Redemption. This is obviously less applicable. Rehabilitation of a few major war criminals seems unlikely, and even if it might happen, seems far less important than the other considerations, the other 5 reasons. The third one, though, is more important: deterrence. It's what we're going to look at more today. It's to deter potential abuses. For instance, if your state has very strict punishment of death, say several years imprisonment, it might deter others from committing the same crimes. It might also deter you from committing the same crime again. What about the ICC? Well, this is probably the most important argument for the ICC. So let's look at it in more detail. Who does the ICC potentially deter? Well, given the relatively small number of prosecutions compared to the number of those who are engaged in mass atrocities worldwide, the likelihood of prosecution might not seem very high. So it might not seem that it's actually going to deter many people at all. Or it might not seem that they're rational actors that really weigh up the costs and benefits of being prosecuted. But the argument goes, for certain individuals, such as states and rebel leaders in Africa, the chances of international prosecution are in fact much higher. For some, the possibility of facing prosecution might significantly affect their cost-benefit calculations when considering whether to engage in mass atrocities. But what's really important here is not prosecutions themselves by the ICC, but rather the fact that it works through the process of what's called positive complementarity. What this means is that the ICC strategy is to prompt otherwise reluctant or incapable domestic legal institutions into launching their own prosecutions, particularly after the launch of preliminary examinations. Let's look at an example. The ICC and US put pressure on the Colombian government to reform its domestic legal institutions, which in turn resulted in seemingly impressive results due to the incentives and threats by the ICC. It essentially said that unless it started to prosecute properly for crimes during the Civil War, it would do so. The ICC would do so. And this gave a very bad impression. This would give a very bad impression to the rest of the world of the state of criminal justice in Colombia. So Colombia felt pressured by positive complementarity to do something rather than to hand the case over to the ICC. So what this means is that potentially the largest deterrent effect for the ICC is likely not to be on those prosecuted, but rather others related to the situation. By prosecuting some of their main offenders, others might be encouraged to cease their abuses, and others involved in the situation might be deterred from committing similar abuses. Others will face the possibility of not only international but also domestic prosecution, given positive complementarity. So there are 2 ways of being prosecuted. Internationally by the ICC, only a handful of cases; domestically, many more cases. And the ICC pushes the domestic institutions into action. So far, I've focused on the direct worries about going to prison and being tried. But the worry about imprisonment is only one part of this deterrent effect. There are also significant reputational costs that are raised by an ICC action. being subject to an ICC investigation can result in a loss of legitimacy. If your government or rebel group is being investigated by the ICC, it can delegitimize you. As I mentioned already, there's the Bolivia case that seems that it was politically motivated by the government referring the rebels to the ICC. We've also seen that John Bolton, and the US government more generally, spoken very heavily against the ICC. They seem to care about it to some extent. So if you're prosecuted by the ICC, you're seen as pariahs, as a sort of state or rebel group that commits atrocities. So domestically, it's not just the threat of imprisonment that stops us committing crimes such as stealing. It's also the worry about being tainted by the investigation and the worry about being under trial. It would be extremely embarrassing for you if you were subject to an investigation or a trial. You have to explain it all to your friends and families what's gone on. So it seems that the ICC can isolate groups in this way by providing a clear incentive not to commit abuses because of reputational costs. Let's look at an example to flesh this out. It's been reported that the announcement of preliminary investigations into serious human rights abuses in Guinea, in West Africa, really worried members of the junta. So they supported the inquiry into the abuses and statements from the office of the prosecutor, which helped to avoid further significant violence and a grave deterioration of the situation. Now, we've already spoken about positive complementarity. This is an intentional strategy of the ICC, focused on ensuring accountability for the worst sets of crimes. But there is also unintended positive complementarity, where there's prosecution for other crimes, such as other human rights abuses, even though the intention of the ICC is on high-profile cases. It's been found that states under investigation by the ICC try 3 times as many state officials for human rights abuses. This is because of what's been called the willingness game. When under threat from the ICC, states attempt to show willingness to comply with international norms in order to maintain their legitimacy. And whilst the spotlight is on, certain NGOs, pressure groups, attempt to improve accountability for crimes whilst it's sensitive to international attention. So they use the spotlight to improve the behavior of the state. While states are willing to comply, NGOs pile under pressure and get the states to do even more. This is unintended positive complementarity. So in sum, the ICC can deter those engaged in the actual abuses, and those that might consider actual abuses through the threats of prosecution by the ICC, but also domestically. This is through intended positive complementarity, which increases the chances of domestic prosecution for serious crimes, and unintended positive complementarity, which increases the chances of domestic prosecution for less serious crimes. It also imposes reputational costs, which can further deter abuses. Now, obvious reply here, obvious objection, obvious query, is that the deterrence does not fully work. There are obviously still lots of mass atrocities going on worldwide. And the powers of the ICC are highly limited, highly circumscribed. It can deter only those under its jurisdiction or those where it is feasible that there could be a UN Security Council resolution. And so states that have cover from one of the P5 or the permanent 5 members of the Security Council, Russia, the UK, China, France, and the US, would not be likely to be subject to a prosecution. And even if there is a conviction, this might not actually make much of a difference. Other states could, other rebel leaders, other authoritarian leaders could step in to fill the void. So, for instance, the trial of Jean-Pierre Bemba, he was for a while imprisoned under trial, but later acquitted. This didn't stop the violence in the Democratic Republic of Congo. Now, in reply, defenders of the ICC accept that sometimes it's going to be very difficult to deter, and it's not going to deter all potential crimes. The whole point of it, they argue, is to raise the costs of violations. It's to disincentivize international crimes. For some, the disincentive of a potential prosecution and delegitimization won't matter or be sufficient, but for others it might. And this is where their argument rests. It's not to say that it's going to work for everyone, it's to reduce somewhat the level of human rights abuses, really serious human rights abuses. That's one objection to deterrence. It doesn't really work. Another objection is that it uses someone as a means. So deterrence theory in the ethics of punishment is widely seen as consequentialist. In other words, utilitarian, or more simply, instrumentalist. All about the consequences. All about the consequences of punishment. One standard objection is that it uses the punished as a mere means. If states want to try to ensure that crimes do not happen again, they can pressurize the judiciary to hand out extremely harsh penalties that go beyond what defenders actually deserve for a relatively minor offense. So the judiciary, the judges, might completely overlook previous good behavior, overlook all mitigating circumstances, or the crime was only a first offense, for instance. This issue arose with the response to the very harsh sentencing in the British riots in 2011. For instance, a Manchester mother of two was sentenced for 5 months for receiving some stolen shorts, despite the fact she hadn't actually taken part in the riots. The UK government justified giving such harsh sentences on the basis of trying to deter future riots. So the objection then is that such sentences were highly disproportionate. They used those punished as a means to deter future violations. As the famous philosopher Hegel argues, to justify punishment in this way is like raising one stick at a dog. It means treating a human being like a dog instead of respecting his honor and freedom. Does this objection apply to the ICC? Probably not. The sentences, it seems, have been largely proportionate, in line with what the convictees deserve. But what this means is the ICC is not based purely on pure deterrence. If it were, it might hand down extremely lengthy and brutal jail sentences to those that it convicts. Instead, like most systems, legal systems, it also takes into account desert. This takes us to the next justification. The fourth reason is this: retribution. Those who defend the importance of retribution are called retributivists. The argument here is that punishing people is required because people deserve to be punished. You can see this as intrinsic or deontological or non-instrumental. Regardless of the broader effects of punishment, the argument goes, certain people deserve to be punished for what they've done. And regardless of whether it deters crime or expresses wrongdoing or rehabilitates people, certain people just should be put in prison. You might apply this to the ICC. Certain people should be put in prison for the crimes that they've committed against the Rome Statute. So, for instance, it's important to bring to trial Assad because of his abhorrent behavior in Syria. He should endure some harm, such as the restriction of his freedom of movement by imprisonment, even if this doesn't do much to deter future crimes. So this claims that criminals should be prosecuted according to their deserts. What matters here is that it's in proportion to the degree of the seriousness of their crime. They should get what they deserve, no less but no more. So punishing people for more than they deserve, as the riots case I've just given, would be wrongful on this account. Now, one standard worry here about retributivism, is that it can be difficult to determine what criminals actually deserve. So should, for instance, there be an eye for an eye, a murderer should a murderer be killed? This doesn't seem so significant when considering really serious cases that we're going to focus on we're focusing on this week that are dealt with by the ICC. It's pretty uncontested that those that engage in mass atrocities, war crimes, crimes against humanity should be subject to years of imprisonment. The more interesting question is how important desert is. Is this really a weighty reason to try to launch a prosecution? Suppose, for instance, that launching a prosecution is going to be very difficult and it's going to make it much harder to secure lasting peace in the country, where you could instead offer an amnesty. Should the prosecution still be launched in order to ensure that leaders such as Assad get what they deserve? Or is it more important to secure peace in the longer term? How important is it that one person gets what they deserve compares to everyone else, who might have lots of broader effects? Fifth major justification is expressivist. The argument is this: launching prosecutions can help in the establishment of international norms against the crimes in question more generally. So this is similar to the argument we looked back in week 4 for naming and shaming. We saw that one of the claims is that naming and shaming can help to uphold morally valuable international laws and norms. The same is said to be true of international criminal prosecutions. The launching of such prosecutions helps to very clearly show expression of wrongdoings of the crimes. In doing so, it helps to further establish that such crimes are wrongful. In fact, the establishment of legal prosecution for the violation of the laws of war are one of the clearest things that you can do to express, for instance, that mass atrocities are wrong. And this, in turn, can delegitimize future mass atrocities and other crimes. It's very clear, to put it in terms of the language we used in week 4, that this is not an appropriate standard of behavior. So in this context, the renowned legal philosopher David Luban argues that speaking law to power is the major point of international criminal justice through an expressivist mode, with the aim of norm projection and dissemination through trials, punishments, and jurisprudence. Now, by launching an investigation or prosecution, the ICC can further increase the sense that crimes are subject to a system of legal accountability and so thoroughly delegitimized. With every action, the ICC augments the sense that there is a system of accountability that expresses the wrongness of those engaged in these crimes. Without the action and a system of legal accountability, it might seem that it is condoned. Well, why does this matter? Ultimately, it might seem to matter, going back to deterrence, about deterring crimes. It's important to have norms, that is, so that they deter future crimes. But it also seems important intrinsically. It's important, that is, to live in an international society that does not endorse or fails to condemn mass atrocities. There's something intrinsically valuable, this argument goes, about having an international society that's based ultimately on the rule of law, at least for the very worst crimes, where those who commit the worst sorts of abuses are ultimately held accountable. Now, one reply to this expressivist argument is that because of the limitations of the ICC, remember the three ways that it prosecutes people, those limitations, it doesn't fully express the wrongness of its abuses. It's argued that the ICC can't act, of course, in many cases outside of its jurisdiction, and has only undertaken a handful of trials, as we've seen. So it might not do really that much to contribute to the delegitimization of the crimes. And it's argued that it might not do much more in terms of accountability and actual cases, given its limitations. Yet on the other hand, you might think still having the ICC present is vital to hold still some accountable, particularly those at the very top, to show that there is not widespread impunity for everyone, and still helps to reinforce and express that sense of wrongdoing when there are serious human rights abuses. Okay, that brings to an end part 2.